going to have as our lunchtime talk. This is an issue that many of us think about, wonder about, and have brought to us a stunning amount of misinformation about. So when we were wanting, we knew clearly we had to have someone talk about HIPAA and FERPA, and we wanted to have a talk about common myths about HIPAA and FERPA. So we said, well, we want to have it at lunchtime, and we want to have it titled something like 3 Common Myths about HIPAA and FERPA that campus mental health professionals and administrators ought to know. So we spent a lot of time thinking, who could give this talk, who could give this talk? And then someone said, you know, you should really think about contacting Steve McDonald out at the Rhode Island School of Design. So I said, okay. So I went to the website and found among the talks that Steve has given, I think it was 8 common myths about HIPAA and FERPA. So that felt to me a bit like the harmonic convergence right there. So we were fortunate enough to get Steve, and I think for those of you who were at session 3 yesterday, you just see his whole way of thinking about the law and the role of an attorney, how refreshing and clear it is. So I am delighted that for our lunchtime talk, we'll have Steve talking about myths about HIPAA and FERPA. Steve is going to speak. We will then have some time for questions, and then we'll break to have about 10 minutes before our 1:30 panel begins. So, Steve.
So thank you. So when Stephen called to ask me to speak, he did say he wanted me to talk about 3 myths about HIPAA and FERPA. I'm not very good at following directions, or at least not very good at counting, so I may throw in a few extra ones here as we go along. So bear with me. Here we go. So there is a lot of misinformation about FERPA and HIPAA and the interplay between the two, and sometimes if you know just a little bit about them, it seems like there's this sort of endless feedback loop between them where one defers to the other and just keeps bouncing back and forth, and which one prevails and whatever. And it's actually far simpler than it seems. That's what I'm going to talk about. So here are the 3 main myths I'm going to talk about. First of all, FERPA applies only to educational records, that is academic sorts of records, and therefore has nothing to do with records pertaining to a student's medical or mental health. Second, that instead of FERPA, we're talking about HIPAA. The HIPAA privacy rules in particular are what governs the disclosure of student medically and mental health related records. And number 3, that under those set of rules, records that do pertain to a student's medical or mental health can be disclosed only with the student's consent. None of those is true. So let's go into that. So we'll start at the very beginning, and just a little primer on FERPA. FERPA stands for the Family Educational Rights and Privacy Act of 1974. It is about to turn 40 years old. You do have to decide whether you trust anyone who's over 30 or not. It is also commonly known, you probably have heard it referred to as the Buckley Amendment, for those Buckley waivers that you may have all signed in high school for the recommendation letters. That's after Senator James Buckley of New York, who was the primary sponsor of FERPA. Those of us from Rhode Island think of it, however, as the Buckley-Pell Amendment, because our beloved Senator Pell, better known to you for Pell Grants, actually was also a primary sponsor of FERPA. I personally think of FERPA, however, as the Rodney Dangerfield of statutes. There is a great deal to it, but it does not get nearly the respect that it deserves on our campuses. So this is the overarching structure, the very basic structure of FERPA. In very general terms, there's a lot packed into that in general, and we'll get into a little bit of that today, but not all of it. If you are a college student, it's also different at K through 12, but if you're a college student, you have 3 basic rights. You have the right to have some control over who gets to see your education records. You have some right to see your own, to inspect and review your own education records. And in certain limited circumstances, you even can require us, you can compel us to correct, to amend your education records when they're inaccurate. Of course, that begs the question then of what the heck is this thing called education records? That's the organizing principle around which all of FERPA hinges. So here is the definition right out of FERPA. Education records is records that are two things. Number one, directly related to a student. Number two, maintained by an educational institution or someone acting on behalf of those things. Seems pretty simple. It's pretty broad. But I'm a lawyer. I'm going to make this more complicated. In order to fully understand the definition, you have to understand some of the individual words and phrases. So for today's purposes, we're going to talk about what is a record, what is directly related, what is a student, and what is an educational institution. We'll start with the easy one. Educational institution. For purposes of FERPA, an educational institution is any public or private institution that receives funds under any program administered by the Department of Education. Anybody here from a school that takes federal financial aid? Sorry, you're stuck with FERPA. This is one of the many strings, many strings that come along with the money we get from the federal government, without which we really could not operate. There are a few colleges. Patrick Henry College does not take money and don't have to worry about FERPA. Grove City College used to. They do now. Hillsdale maybe, I'm not sure. But virtually all of us are subject to FERPA because we are what FERPA defines as an educational institution. So next, record. Key phrase. Record means any information recorded in any way, not just words on pieces of paper, the things we usually think of as record. Those are covered as handwritten and print records, but electronic records are also covered. Computer media. Email is a record. All our student information database systems are records for purposes of FERPA. Video and audio tape and film. Somewhere in the dusty basement of your library, you may still have microfilm and microfiche. Those are records. If for some reason on your campus you choose to keep your records carved into stone tablets, those will be records for purposes of FERPA. The medium does not matter. The medium is not the message for purposes of FERPA. This is intended, as all the definitions in FERPA, to be quite broad and to be quite almost all-encompassing. There is one exception to this, and here's my first extra myth. Education records does not include information that is recorded only in the synapses of your brain, which is to say personal knowledge. FERPA is a records statute. It governs records and it governs information from records. It does not govern information generally. So if you're walking across your campus and you see a student doing something that concerns you, at least as far as FERPA is concerned, you're free to tell the world. FERPA has nothing to do with that information because it's recorded only in your head. If you record that information on a piece of paper, the piece of paper becomes subject to FERPA, but your personal knowledge still does not. Again, it's a records statute. What about student? Student is any individual who is or has been in attendance at an educational institution. Interesting things embedded in there in terms of timing. So first of all, here we go. Applicants are actually not covered by FERPA at the time they are applying. FERPA applies to students. So not until they are accepted and they accept your offer of admission and they in some way begin to attend your institution does FERPA begin to cover them. If they do that, FERPA reaches back and grabs their application files. But for all the students who are not admitted or the students who are admitted and choose not to come, not a FERPA record because they're not students. They're not your students. At the other end, it also goes on for quite a long while. FERPA rights continue even after the student is no longer a student. FERPA rights in any particular record cease to exist only when one of two things ceases to exist. Either the record itself, if a record is destroyed, there's no longer a FERPA protected record, or the student. FERPA rights die with the student. So if you have records about long ago alums, when I was at Ohio State, we got lots of requests for records about Jesse Owens, the famed Olympic athlete who was one of our alums, and he was dead. So as far as FERPA is concerned, his records were not an issue. This is by analogy to common law rights of privacy, which in most states, common law rights of privacy end with death, or expire along with the person. Directly related, this is actually an enormously complicated term. There's all sorts packed into that, but for our purposes today, we can be satisfied simply with a record is directly related to a student if it is in some way personally identifiable to that student in very broad terms. So not just a name on a record, not just an address, not just a student ID number, but anything that would tie a record to a particular student, including perhaps just a collection of demographic data that somebody could look at and say, oh yeah, that's Steve, if they could figure out the things with reasonable efficiency. So the bottom line is, from my perspective, Congress did us a real disservice when they used the term education records, because education has nothing to do with this. It's not education records, educational records. The term is education records. It's not academic records. Those things are all certainly covered. Transcripts, exams, papers, all those things are certainly FERPA records and are at the very core of what FERPA is concerned about. But this definition is intentionally extraordinarily broad and intended to sweep into encompass almost everything. So financial aid records, the student's financial account records, housing records, disciplinary records if the student has them. If the student's an athlete, those records. Photographs. People don't think about that, but photographs of your students, at least if they're good photographs and you can tell who it is, they're personally identifiable, those are education records. Unofficial files, I often hear people say, well, we don't treat that as a FERPA record, it's unofficial. To which my response is, I don't care. Was there anything in the definition that said official versus unofficial? No, it doesn't matter. Almost everything that we have on our campuses, any form of record we have on our campuses that in a very broad sense pertains to our students is covered as an education record under FERPA, except for these. There's always exceptions. Within that very broad definition, there are 5 things that are carved out for various policy reasons. So sole possession records, which are essentially sort of memory jogger notes people keep for themselves, were never intended to be shared. Certain law enforcement records, certain employment records, alumni records, records that you create about your students after they're no longer students. And for our purposes today, the important one, treatment records. So treatment records under FERPA are not education records. They're not subject to the whole panoply of FERPA. What are treatment records? Another definition, which will seem a little complicated, but it's not terribly. So it's records on a student that are 3 things. First of all, it's made or maintained by a physician, psychiatrist, psychologist, or other recognized professional or paraprofessional acting in their professional capacity. So not just the people on the list, but that could include licensed clinical social workers, nurses, all sorts of people, EMTs, anybody who has some form of medical training and so forth. Those people have to be acting in their professional or paraprofessional capacity. The records have to be maintained, or used only in connection with treatment, and they can be disclosed only to individuals providing treatment. So it sounds a lot like medical records, right? It's not. So here we go to we'll start tearing apart the first myth here and focus on two particular parts of this definition. So first of all, subsection 2 says it has to be made, maintained, or used only in connection with treatment of the student. If you think about it, you have lots of things that are medical records on your campus that were not made, maintained, and used only for that purpose. In some guidance, the federal government, the Family Policy Compliance Office, which is the office that oversees FERPA, said, for example, that records from a disability services office, which certainly are medically related, are not treatment records, because the purpose of the disability services office is not to treat the medical or mental health condition. It's to deal with other issues. So those records are education records. They're not treatment records, not excluded. They are actually education records subject to FERPA. And there are all sorts of other medically related records in various offices on your campuses that were not made, maintained, and used only for that purpose, and therefore would be considered education records. Let's also look at the last part of that. Disclosed only to individuals providing the treatment. FERPA, as we talked about, is a non-disclosure statute for the most part. For things that are education records. But we've carved treatment records out of it, so they must be disclosable, right? No, because built into the definition is they can't be disclosed to anyone other than people involved in the treatment if they are going to be treatment records. Now, that's just a definition. It's not a prohibition. You are free to disclose, as far as FERPA is concerned, treatment records. But if you do that, from some more guidance, they become education records. The second you want to share them with someone else, they become education records and are subject to all of the restrictions that apply to education records, all the non-disclosure restrictions and so forth, as well as the other rights, including the right of the student to inspect and review the records and to seek amendment of the records. Huh? What the heck is he talking about? So first of all, almost every, and I'll come back to the virtually here in a few minutes, almost every record that we have on our campus that pertains to a student's medical or mental health is one or the other of those two things. It is a treatment record or it is an education record, both of which are governed in some way by FERPA. Why would they make this distinction then? What is the reason for that? Well, the reason is not because they wanted to make treatment records freely disclosable to anybody, just to pass them out. The definition doesn't allow you to do that, and if you do that, it brings it back into FERPA as an education record. And so all of those records are always subject to the limitations on disclosure under FERPA. We'll talk more about those as well. The real reason for this distinction, which seems bizarre at first, but is actually quite simple, is simply this. Congress, when Congress created the inspect and review right under FERPA, it's a virtually absolute right. Students have, with two extraordinarily narrow exceptions, they don't get to see mom and dad's financial records submitted for financial aid, and they don't get to see the guidance counselor letters for which Buckley waivers were signed. Everything else they have an absolute right to see if it is an education record. Well, Congress said, maybe we don't want to do that for treatment records. Instead, we are going to defer to state law on when patients can see their own medical records. And in most states, there are exceptions that will allow a medical professional to withhold certain patient records if it would harm the patient to have access to those records. And so Congress said, we're going to let the states figure that one out. As long as you don't disclose it outside of the chain of treatment, we fall on that. If you do disclose it to someone outside the chain of treatment, which is fine under FERPA, it becomes an education record and the student gets to see it. Trade-off decision you have to make for yourself. So that's the first myth. Let's go on to the second, which has to do with HIPAA. FERPA has its sort of central term, education records. HIPAA is organized around the concept of health information. And let me just highlight a few of these words. Health information includes, among other things, any information that is created or received by a school or university and that relates to the past, present, or future physical or mental health or condition of an individual. Students being individuals would be covered there. So it seems like HIPAA has something to do with this, right? No, nothing, almost nothing. HIPAA does not actually protect health information. The key term under HIPAA is protected health information. That's what is subject to HIPAA. And if you parse through the bazillions of pages of regulations under HIPAA, you will come to the definition of protected health information, and in particular, certain exclusions. Protected health information under the definition excludes individually identifiable health information in education records and in treatment records. HIPAA is basically saying FERPA governs that stuff, not HIPAA. HIPAA has nothing to do with your campus records about your students, with the one exception I mentioned, virtually nothing to do, which is this. If you happen to have a hospital on your campus that serves the general public and someone who is one of your students goes to that hospital for treatment, your relationship with that person at that moment has nothing to do with the person's student status. So the hospital records, which almost certainly were already subject to HIPAA, those records pertaining to that particular student are subject to HIPAA. But all the things in your student health center, your student mental health centers, the counseling centers, all of those things are subject to FERPA, not to HIPAA. HIPAA has nothing whatsoever to do with that. Congratulations, that thousands of pages of regulations, you don't have to worry about them. You can voluntarily comply with HIPAA if you wish to do so, and many schools that are covered entities and have HIPAA requirements do that because it's administratively simpler to do it, but not because they're legally required to do it. FERPA governs it, not HIPAA.
Steve?
Yes?
So does that mean that if I am the director of a campus counseling center, so if I am the director of a campus counseling center, we treat only students at the campus counseling center, no one else, then I don't need to comply with HIPAA. Is that the take-home message?
You do not have to comply with the privacy rules of HIPAA. If you do bill for insurance, you would still have to comply with the administrative rules, which is the coding rules about, getting the insurance companies to pay the right thing. But who cares? But it doesn't matter. It doesn't matter even if that student health center is treating other people. So if your student health center, as it is on some campuses, will do minor things for employees who happen to be injured, that doesn't take it out of FERPA or put it into HIPAA. It is still, the student records are still subject, their education records subject to FERPA, not protected health information subject to HIPAA. So forget about HIPAA. Congratulations. It's much easier. So let's go back to FERPA now and talk about what FERPA says, and this is myth number 3 about disclosure. The general rule under FERPA is a quite broad prohibition against disclosure. You can, the default rule is you can disclose an education record or information from an education record, even if you don't actually transfer the physical record, you just talk about it. You can do that only if you have first obtained a signed, dated, written consent from all the students to whom the record pertains that says what can be disclosed, why it can be disclosed, and to whom it can be disclosed. Informed consent, essentially, informed consent thing, which is a good rule. But that's the default rule, and FERPA carves out about 16 or 17 at the last count exceptions to this rule. I'm going to talk about 3 of them. And here's where you don't need the consent. One of the key ones under FERPA is we are free to disclose any education record to any school official whom we have determined have legitimate educational interests. School official does not mean officer, like the president. It doesn't even necessarily mean official. It doesn't even necessarily mean an employee. It can be agents who are working on your behalf, an attorney you've hired for something, an accountant you've hired for something. If you've outsourced your email to Google, Google can be a school official. And legitimate educational interests, like education record, also has nothing to do with academics. That essentially has been defined as simply job-related need to know. This is what allows us to operate our campuses and to share information around campus. So anything that is an education record, we can share with any employee, any agent who has a job-related need to know. Pretty broad. Next one, we may disclose any education record at all to mom and dad if mom and dad claim little Johnny as a dependent on their most recent federal tax return. You have to find out, you have to ask. It's not always a fun conversation when mom and dad are calling up and asking about something. Could you just fax me your most recent federal tax return? Hold the phone out when you do that. I want to make a key point here too, which is age does not matter. This is another thing that is commonly misunderstood. K through 12, the FERPA rights belong to mom and dad, not to the student, until the student becomes 18. And at some point during senior year, FERPA rights start transferring from mom and dad to the student. Nobody actually knows this is going on or pays any attention to it. But at college, you simply have to be a college student. Your age does not matter, and even if you're a minor, mom and dad no longer have a legal right to demand information. You can disclose if they claim little Johnny as a tax dependent, but you're not required to disclose. When Doogie Howser went to Harvard Medical School at 13, he owned the FERPA rights. Mom and dad no longer had any rights, not enforceable rights. And the third important one for our purposes is we may disclose education records, appropriate information to appropriate parties in connection with an articulable and significant threat to the health and safety of the student or to other individuals. This is a Tarasoff-like standard, but it's quite a bit more flexible than a Tarasoff standard. Every state has their own version of when you have a duty to disclose to potential victims or so forth of things. This is quite broader and more flexible. And the concept here is that the response, the disclosure, needs to be tailored to the particular circumstances. Sometimes it could be quite broad, sometimes it would be quite narrow. So in guidance, they've talked about, for example, if you have a student who has measles, you probably could tell every class that the student's been in, hey, you ought to go check, or the dorm, you ought to go check to see if your immunizations are up to speed and so forth. But for other sorts of things, it would be much more narrow. Mom and dad might well be somebody you could talk to under this as well. So it's a fairly flexible standard. And so it's actually not all that hard under FERPA to disclose education records, including student, medical, and mental health records. There are a bunch more exceptions. These are the 3 ones for our purposes. However, while all that is said, FERPA is largely irrelevant, and FERPA permits disclosure under all sorts of circumstances. Keep in mind that FERPA does not require disclosure ever except to the student. The only person who ever has a right to see an education record is the student to whom the record pertains. Everything else is within your discretion. Allows broad disclosure, but it does not require any disclosure other than to the student. Also, another bonus mythbuster here, FERPA does not exempt the medical professionals on your campus from complying with their own state medical confidentiality rules. So your counseling center, as far as FERPA is concerned, could disclose everything to lots of people. But under any state law that I'm aware of, it would basically be a TerraSoft standard before they could disclose anything or consent. That's the medical professionals. That doesn't mean that the ADA office is subject to that, because they're not subject to medical confidentiality. That doesn't mean that the Judicial Affairs Office, if they have access to medical information for a particular case, have that, because they're not medical professionals. But they also may have other obligations. So your Disability Services Office has other things like ADA. Now, ADA confidentiality requirements are much clearer in the employment context than they are in the student context, but there are requirements there. State common law privacy principles may apply to student records as well. So the fact that FERPA allows broad disclosure does not mean that you're home free. You still have to think in the particular context who you are, what you're doing, and whether there are other legal requirements as well. So at least as far as FERPA is concerned, quite broad, some other things here. But I want to sort of just sum up with a slightly more elaborate version of what my concluding comment was yesterday at the end of session 3, and just a little soliloquy about the limits of law and lawyers and so forth. People often look to us to answer these questions and to tell us, what can I do? Can I disclose this or not? Well, first of all, the can question to me is not the right question to ask a lawyer. Can is a broad universe of everything that is possible. Can I drive my car 100 miles an hour? I suppose. It probably goes that fast. Why are you asking me? What do I have to do with that? The right questions to ask a lawyer are this. May I do something? May I drive 100 miles an hour? No. Must I do something? Must I have a driver's license? Yes. You can ask those things. You will notice, however, that there's a whole lot of space between those 2 lines. Within those 2 lines, the law has absolutely nothing to say about what you do. You get to make choices, which is the good news. The bad news is you have to make choices. This is what I think of as the policy zone. This is a very scary place for a lot of people because the lawyer can't help them with that. They want somebody to make a decision. The lawyer can't actually make that decision. There are all sorts of other things that factor into that. The real question that we have to ask here is this one. What should I be doing? The lawyer can help you think that through, but can't tell you what that is. And in order to answer that question, you have to take into account what's your mission? What are your values? What are you trying to accomplish? All sorts of other things besides just the law. So my basic point here is don't obsess about FERPA. Certainly don't obsess about HIPAA because you don't have to worry about it all, but don't obsess about FERPA and these kinds of things. And again, focus not so much on the law, but focus on what it is you're trying to accomplish. What is it you really want to do? What is the right thing to do? And my personal hope for this conference is that the discussions we've been having help to shed light on what the answer to that question is. And that's the real question. The lawyers aren't going to solve the rest of this stuff for you. We can just tell you what the parameters you're operating in are. So with that, that's what I have to say. Any questions?
On a college campus, does disabled student services have a right to disclose the diagnosis?
Did everybody hear me?
On a college campus, does the Disabled Student Services have a right to disclose a student's diagnosis?
So that's a very abstract question. As I said yesterday, I'm a lawyer, so I have to say it depends.
Okay, so
FERPA would allow you under all those circumstances, but ADA and other obligations may restrict you. So to whom do you want to disclose, and why do you want to disclose?
to the behavior intervention team or to the discipline committee?
Probably that's going to be okay. Certainly it's okay under FERPA.
What about under ADA?
The ADA rules, as I said, are much clearer under employment law, the employment side, than they are on the student side. And I think if you have a good faith reason to think that the behavioral intervention team needs to know something, probably can be shared. Now their ability to share it is still restricted by FERPA, and your requirements to disclose it are, there aren't requirements. But
Right.
yes, FERPA is intended to allow for those kinds of exchanges precisely so that the right people can be addressing the question. And I don't think there's anything in ADA. If you have a good faith belief that the behavioral intervention team needs to know this information, I don't think there's anything in the ADA that would restrict that disclosure.
Okay, and the second part of the question is, if a student's suicidal, are faculty and staff at a college required, that goes under the must they do something to protect the student?
This has nothing to do with FERPA. This is a general question of, do you have a duty to go to the aid of someone? And that's going to be a state law question, but in most states, unless you have a special relationship with the person, you have no duty whatsoever. Some states probably would say that a school has that special relationship with the student and has some obligation to deal with it, but some states may not. So again, it depends in part on where you are.
I see.
Again, whether you have to is not always the exact right question. There's more to that. Yes. Should I is the question I'm asking myself there.
I think I'm just reiterating the obvious, I think, for my reassurance, but any FERPA records that we need to release, we can with the student's written consent.
With consent, you always can release. But even a consent does not require you to release. That's an important thing to keep in mind. If a student comes in and says, here's a written consent, I want you to show all of my records to mom and dad or my lawyer or whoever, you don't have to. It allows you to, but you still don't have to.
Our situation, which it's the overlapping, I guess, jurisdictions, we're both field educators, so we have MSW students who go to internships, and in their field application they might disclose a physical or mental disability or criminal record, and it's do we want to disclose that to the field agency? Our goal is the student's benefit to find a placement where they'll be accepted, or they may or may not pass a live scan kind of thing, but we usually get a written release from disability services and ask the student what they'd like us to disclose to the agency.
So if you want to disclose to the agency, you could do so under at least two circumstances. One, with the student's consent, as you're talking about. If the student consent, you can do that. And the other is if your relationship with the outside agency has been set up so that the agency is in effect an agent of the institution for that purpose, it's a school official.
We have a service learning agreement with them. We have an MOU. I don't know if that makes them part of the institution, though.
Well, they don't have to be part of the institution. A contractual relationship with an outside vendor or contractor can make that contractor a school official if the contract designates that person or entity as a school official and incorporates the restrictions of FERPA. So when you share information with that agency, if they are a school official, they stand in our shoes. So they couldn't disclose it in any way that we couldn't disclose it. But they have to be clear on that.
Thank you.
Anything else? Back in the back. There's always questions about FERPA.
So just to be clear, I'm a psychologist working in a counseling center at a college. The highest law that would apply to me in terms of confidentiality would be state law?
Well, FERPA does apply to you. It just doesn't restrict you particularly. So the most stringent law that will apply to you is almost certainly your state medical confidentiality laws for your profession.
Okay, and I still need to comply with that even if I'm receiving encouragement from campus officials to share information with them.
You have no right. FERPA does not. FERPA is not a sword. It does not cut through your medical confidentiality requirements. So FERPA would allow it, but you have to comply with whatever the most stringent set of rules are. And in your case, that's very likely more stringent than FERPA.
Yes. All right. Thank you.
But Steve, in that case, could school officials determine as a matter of policy that a condition of receiving treatment at the campus counseling center is that the student give consent for the disclosure of records to school administrators?
That's a state medical confidentiality law issue, and I don't really know the answer to that. I do know the FERPA answer, which is you cannot condition the provision of educational benefits or services on a FERPA waiver. You just can't do that. I suspect that's probably true under state medical confidentiality laws, but I'm not expert in that.
If that were true, I would love to know that. Because I would love to be able to tell folks at campus counseling centers that when an administration comes to you and says you must have the student sign this, that a response might be, in fact, we cannot make this conditional upon, we can't make treatment conditional upon signing this consent.
Consents typically have to be voluntary, and that's not really voluntary. Which was the Sachs scholar who was investigating this very issue? I think he has a new assignment.
Yeah.
He's
Where
not
those
here.
Sachs scholars are being fed, I think.
Yes.
So with regards to that, isn't our license, being a psychologist, I'm an LCSW, doesn't that override everything else in terms of the protecting the confidentiality of the patient in treatment regardless of the setting?
Yes, basically. I mean, FERPA is quite flexible, but you, in your role, have to comply with both sets of rules, and whatever the more stringent set of rules is, you're subject to it. Other offices that don't have your licensing and don't have the same confidentiality requirements can just worry about FERPA. But you can't give them the information in the first place, probably.
We have Jim Price is rushing toward the microphone.
And this is a little out of place because it's not college, it's high school, but I'm on the same issue where the parent has an absolute right to the educational information and there's a more limited release that the therapist has. Would you say that the state law governing the fact that they think this might do harm to the child in releasing the information would outweigh FERPA and therefore it should not be released? They should follow the state law?
You definitely would still have to follow the state law, even at K through 12. But state law for minors is typically different. So mom and dad just probably have rights under the state law as well as under FERPA.
Assume that the state law says that the parent has a right to the clinical record unless the therapist believes in their professional judgment that it would be a harm to the child to release it, and that's what the therapist in their professional judgment believes. Do you think then you can ignore the FERPA mandate to share that information with the parent?
Yes, because that is going to be a treatment record, probably, in the circumstance you've described, and therefore it's not subject to the inspect and review right. And so as long as it's not shared outside of the chain of treatment, yes, you're absolutely right.
Steve, we now need to begin preparing for our 1:30 session. Thank you very much.